Forget New Year, New You. This season is about slowing down, locking the doors, and cozying up at home with the one you really want to do nothing with. Your dog. After the holiday chaos, those quiet nights with a blanket, a podcast, and your pup feel like the reset you actually need. Ollie helps make those moments easier with fresh protein-packed meals made from real human-grade ingredients, so your dog can enjoy some quality comfort food too. Choose from 5 recipes and get a personalized plan for your dog's needs. Meals arrive perfectly proportioned with a scoop and storage container, so serving is fast and mess-free. And with Ollie's in-app on-demand health screenings, supporting your dog is easy, ensuring more cuddles for many years to come. Visit ollie.com/truecrime and use code TRUECRIME for 60% off your first box.
Hey, fans of freedom and open discussion, I'm heading over to Substack, and there's an ad-free audio and video version of The Adam Carolla Show that's going to be waiting there. In the near future, you'll even be able to watch ACS Live, unedited, as we record it, participate in the show via live chat. That'll be coming up very soon. You'll also get an ad-free version of the Adam Carolla and Dr. Drew Show. You'll also get an exclusive to my new podcast, Beat It Out, where I share unpolished ideas with my comedian buddies. The first series of episodes is going to be Jay Moore. You'll get all this and more for the low, low price of $9 a month, a pittance for all we're going to bring you. Subscribe now at adamcarolla.com/Substack, and I'll see all of you in our new speakeasy called Substack.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my new year, but same old host, Brett.
It's true, Alice. Should old acquaintance be forgot and never brought to mind? It's hard to say. But I'm glad that even in this new year, you haven't thrown me overboard for somebody new.
Never, never, never. What am I without you, Brett? But, and Alice. Okay, I'm playing around with my pillows right now to play with my sound. Hold on.
Okay. Your sound sounds fine.
It feels like sounds okay? Okay.
It sounds fine to me.
I'm trying to be in the camera shot for the vertical, but I can't because I want to lean into the pillows. So, sorry, everybody.
The sound is much more important.
I agree. I'm just saying.
Well,
we are back in the new year. Like we said, new year, same old hosts.
Same old
story.
And
we keep getting older. It's like
1 year at a time.
It's like the 1 year at a time we get older. I can't believe it's 2026. Like I didn't even realize it was 2025. I wrote a check the other day. Yeah, who writes checks? I know, that's how old I am. And I wrote 2024. I missed 2025 completely.
Yeah. I feel like, they always say that as you get older, time moves faster. And I don't know if that's true or not, but it certainly feels true.
Feels true. And the thing about nothing new under the sun, Ecclesiastes, I think that's the case in the Delphi case.
That's true. And that's the truth.
We started with this case. Well, the case started obviously in 2017 with a horrendous double murder of Abby and Libby. And then, of course, after many, many years, we were able to get a conviction of Richard Allen for the double murders, 2024. And that was hard fought, of course, because over and over, you may remember, the same arguments came up that went all the way up to the Indiana Supreme Court, back down, up and down, up and down. It seemed like before we reached the trial phase. And now that we have a conviction, many of you think, man, closing out the year strong. 2025 is when we leave the Delphi case behind. But alas, no, because the same arguments you heard at the district level have now been appealed post-conviction by Richard Allen.
Yeah, and this is exactly how it goes. When the verdict came down, we told you what would happen, that this is the way it would go, I think most of us in true crime, we follow the trials, but oftentimes we don't follow the post-conviction stuff unless it's one of those cases where after like 25 years, Scott Peterson saying he's innocent and he's filing a new filing. We follow those, but a lot of these sort of post-trial things we don't see as much. And look, this is an appellate brief we've all been waiting on for a while. It takes a long time to write these. They got several continuances. I expect the state will do the same thing. The wheels of justice move very slowly. And that's something that you can expect. And I think a lot of people out there who maybe don't listen to our show, not you guys, because you guys all know this. Number one, thought of the appeal, man, there'll be some like bombshells in there. It's going to be crazy. Like, we're really going to say all the things that were wrong and point out all the horrible constitutional violations in the appeal. They're going to finally do it, right? And in reality, an appeal always, if it's a good appeal, if it's a well-written appeal, is going to reflect arguments that were made in the lower court, because that's where the record is created. That is where the record is preserved. It is one reason that we were so critical of Richard Allen's defense attorneys at the time, because even though we thought he was guilty and even though we wanted to be convicted, we also understood that some of their antics meant they weren't doing as good a job of creating a record and preserving it as they could have. I think you see that reflected some in this brief itself. But yeah, we want to dive into this. By the way, if you're not a subscriber to the True Crime Times, our Substack, you should do so. I've already discussed this immediately after it came out on there. So if you were a subscriber, you would already know my thoughts. So hey, but that's fine. You can listen here. And we have Alice. That'll be even better. But anyways, with that, Alice, I want to ask you a question. When you open this up, and we all know the focus of the defense attorneys in this case was Odinism. Right? This is an occult murder. That's how this went down. Did it surprise you that when you turn to the table of contents, they don't make the argument for occult murder until issue G, which is the second to last issue, by the way?
Absolutely. No, absolutely. Because from the very beginning, remember, they were throwing out Odinism was like the very first big splash, right? Remember that Frank's motion that wasn't really a Frank's motion, that was a 100+ page press release after there had been a gag order instated. So that had been the case all along. And then they tried to make some other guy did it defense with the Odinism theory. Got thrown out because lo and behold, there was no evidence for it. So of course, I thought the very first thing they would argue would be that they couldn't present their Odinism theory. Now, don't worry too much. They definitely have it in this what is this, 117 pages?
It's in there somewhere.
It's in there somewhere.
It's kind of like the Frank's motion where they didn't make the legal argument until after page 100.
They
don't make the Odinism argument until page 103.
Yes.
Of 113 pages.
Which is a lot of pages to read through. So I was surprised, but they also have different counsel.
Right. And
which is typical. By the way, your trial, those are different skill sets. I was just explaining to someone today that the trial court, like jury trial attorneys, it's a different skill set than appellate attorneys. It is not uncommon that if you appeal a case, a conviction, you get appellate attorneys. And there are benefits to that. You have kind of outside attorneys who have not been enmeshed and we call it falling in love with your own arguments. The Odinism argument, guess what? His attorneys at the trial level fell in love with that argument. That's all they cared about, right? That's all they talked about, whether it was the strongest argument or not. You get kind of an outside view of an appellate attorney coming in and knowing what matters on appeal based on the record and what will actually get you results.
And look, I think you look at something like this and you think about it as like a legal work. It's a legal product, right? It's also meant to be an argument to both the court and to the general public, though generally mostly to the court. But I think in this case, even these appellate attorneys who are different, they had to make the Odinist argument. Yeah, it didn't come until issue G of section 3. So there are 3 main sections, right? So there's section 1, which has an A and a B, and A has 4 subparts. I want to hammer home how long it took them to get to this. So section 1 has 2 parts, A and B. Part A has 4 subsections. Part 2 has 1, 2, 3, 4, 5 subsections, A through E. Section C has a 1 with an A through C and a 2. And section D has a 1 and 2. And then there's section 3, which has an A through H. And we don't get to Odinism until Section 3, Subpart G. So it's worse than just G. It's like basically, I mean, it's a throwaway argument. And the only reason I focus on this is just because, as we've said before, this case has had so much misleading, sensational reporting. And a lot of that is focused on Odinism, and that the fact that Odinism was not presented at trial was this massive constitutional violation. And if they believed that, it wouldn't have ended up where it did. I mean, one of the things about when you write an appellate brief, your strongest arguments always go first, because appellate attorneys or appellate judges, even more than trial level judges, they don't have time to waste on you. Like a trial court judge basically has to listen and address all of your arguments, because if they don't, if you make an argument, no matter how foolish, and they don't address it somehow, then that itself can become sort of an appealable issue. Appeals court judges, they don't have to suffer fools. They can just be like, you know what? Issue 1, we'll consider that. The rest of this is garbage. We're not even going to get to it. And if you don't make your strongest argument first, you're a really bad appellate attorney. And these are not bad appellate attorneys. They make some mistakes, as we'll point out, but they're not bad appellate attorneys. So they started with their strongest, what they think is their strongest argument, which ironically actually is the Frank's motion argument. The one, by the way, that the trial attorneys did such a poor job of presenting back at trial.
Right. It's about whether to have a Frank's hearing, not the Odinism, some other dude did it. Remember, we always said, go back and listen. We're not making this up now. Back in the day, we said their Frank's motion wasn't really a Frank's motion, because a Frank's motion is attacking the four corners of the search warrant. And that's what the first issue is all about. Remember, we say that you have the Fourth Amendment right against unconstitutional searches. So even if the police search you and it's unconstitutional and they find a bunch of illegal stuff, if it's fruits of an illegal search, they can't use it. That's how we protect your constitutional rights, is saying you can't do a like, oh, well, we didn't do it constitutionally, but after the fact, we found all this bad stuff. So thank goodness we unconstitutionally searched you, because you can imagine how bad that would be. So that's their first argument, is that there's reversible error because evidence from this unconstitutional search of Richard Allen's home was admitted into evidence, and they were denied a Frank's hearing. That's all procedural, and that's the argument they should have made in the Frank's motion that was actually the Odinism motion.
So just to remind you guys, if you haven't been listening for forever, we did an in-depth discussion of a Frank's motion a while back, but we'll give you sort of a refresher. So if you're reading this, you'll know what the standard is. And I'll say this, I mean, a lot of the stuff they wrote, like they spent 50-something pages on the fact section, which I think was a little too much, frankly. It is more sort of partisan than a typical fact section. A lot of times you try and keep your fact section less overtly argumentative. You want to make an argument, but you want to do it sort of cleverly, right? Because you're not really supposed to in the fact section. They go a little overboard at times, but whatever. I'm gonna give them a pass on that. Once they get to the argument on page 59 of this document, they're talking about this Frank's hearing. And Frank's comes from, it's Franks versus Delaware. It's a United States Supreme Court case. And essentially what happened is, as you guys know, Fourth Amendment, you got to have a warrant to search someone's home. And the rule has always been, if you have a warrant, almost impossible to get that thrown out, right? Like if you've gone to a judge, you've gotten a warrant, that's probably going to stand. Usually Fourth Amendment arguments are about warrantless searches. Can you somehow justify that search? And, if you're following the Luigi Mangione case, there you go. Warrantless search right there. But in this case, you have a warrant. And for a long time, the rule was just, oh, you got a warrant? Okay. Can't challenge it. Well, in 1978, the Supreme Court said, okay, we're not going to open the door very much, but can't challenge it seems kind of silly if you can prove that the police officer lied to the judge to get it. The police officer wouldn't have been able to get this warrant without lying. They did lie. They intentionally lied. So we're going to say that opens the door. But even then, if you take the lie out and you still have probable cause, even with a lying police officer, even with an absolutely corrupt, lying police officer, that's not enough. That's how high the bar is in this case. And I'll just read you what the Supreme Court said. And this is to get a hearing, by the way, because you got to get to a hearing in order to get to a point where you can exclude the evidence. To get a hearing, the defendant must show, one, that a false statement knowingly and intentionally or the reckless disregard for the truth was included by the affiant in the warrant affidavit. Now, as we've talked about before, reckless disregard is a really high standard. This is not you put something that was wrong in there. It's not you were negligent and you put something wrong. It either has to be you intentionally lied and you knew you were lying. You put it in there, you were lying and you were doing it to get this warrant you wouldn't have gotten otherwise, or you were so sloppy with the truth that it's essentially reckless disregard for the truth and something goes into the warrant that's false. That's number one. That's the first thing. And you have to show that with the affidavit's false material set to one side, the affidavit's remaining content is insufficient to establish probable cause. And if you can make that preliminary showing, then you get a hearing.
That's an incredibly high bar. Again, just to even have the hearing in the first place. This doesn't then say you get everything tossed out. And Indiana case law itself says that in evaluating basically whether this Franks issue was decided wrongly by the district court, the appellate court doesn't get to de novo review this. De novo means in the first instance. They have to consider the conflicting evidence in a light most favorable to the ruling that the district court already did. And we've said this before, that the reason there's such a high bar in deference to the district court is those witnesses are coming before the district court judge. The appellate court just has a record, a cold record, words on a page. They don't get inflection. They don't get to see body language. They don't get to see how someone reacts on the stand. So that's why there's so much deference to the district court's ruling. And then the appellate court gets to consider any uncontested evidence favorable to the defendant, but they have to defer to the trial court's findings of fact unless they're clearly erroneous. Clearly erroneous, not, you could go either way. There could be differences of opinions. It basically has to be the district court was so clearly wrong that justice demands that we do something about this.
This episode is brought to you by Progressive Insurance. You choose to hit play on this podcast today. Smart choice. Progressive loves to help people make smart choices. That's why they offer a tool called AutoQuote Explorer that allows you to compare your Progressive car insurance quote with rates from other companies so you save time on the research and can enjoy savings when you choose the best rate for you.
Give it a try after this episode at Progressive.com. Progressive Casualty Insurance Company and Affiliates, not available in all states or situations. Prices vary based on how you buy. And I think this is so important to remember. So we're at the appellate stage. So he's lost at the district court. And this sort of the standard that we're now considering is a very high one. And the standard of review for the appellate court is very high. And as Alan said, this isn't de novo. You're not just walking in there saying, hey, I get a whole new look at this. They have this thumb on the scale. They're not reweighing the evidence. In fact, they're giving all the weight to the prevailing party, which is the state. So they're saying, look, if there's a question about what the evidence is, we're going to assume what the state's saying is true. I mean, that is very difficult. And this clearly erroneous standard, you know, if the trial court makes a finding of fact, we're not going to set that aside unless it's clearly erroneous. Just think about that. So, you know, they're going to make all these arguments in their brief about how like, oh, well, you know, he said, for instance, I'll give you an example, his affidavit. And they say this over and over again in the brief, and this is a big weakness because it's so easily refuted. He says that one of the witnesses told him there was a man walking down the street who was muddy and bloody, but in fact, the transcript, it only says muddy. Well, the problem there, number one, you can see how that would be an honest mistake, right? Not necessarily intentional, but even put that aside. The problem is, at trial, that witness testified. And what did that witness say? Oh, yeah, I told him it was muddy and bloody. And the appeals court can consider trial testimony in determining whether or not there's a false statement. So throughout this brief, they keep going back to this, oh, he said muddy and bloody, and that's not what the witness said. No, the witness said, look, your transcription might not have picked it up, but I said muddy and bloody because I saw a muddy and bloody guy. So guess what? That's now a contested fact. Guess who's going to lose on that? Richard Allen. Because that's the standard. So you can just go ahead and throw that out. That is not a fact the appeals court will rely on to overturn this because at best for Richard Allen, it's contested. At worst, it's definitively against him. And with this standard, they're not going to consider it.
Yeah. So when you read this 100+ page brief. This is why, by the way, you have opposing briefs as well. It reads as if you only read this side, you wouldn't get the full story, because obviously they're trying to write the strongest argument. But the thing is, we've already said this, the prosecution put on a really good case in building a record at the trial level. And so most of what they're saying is contested. This is also, by the way, what you hear YouTubers and a bunch of people who are in the Richard Allen is innocent camp continually saying, that those are the facts that support his innocence, which have been refuted. They don't care that it's been refuted in trial. This brief kind of reads like that, to be honest. It's not giving you the full side of the story. You're not supposed to do that, but I get it. This is all they can argue. That's not the way I argue as an attorney. If the facts are not on my side, I don't, shape the facts in the way they are. But the appellate court is very clear on this. Their standard is clear. They can't shift the standard on this. It's clearly contested, and it breaks in favor of the ruling, which is in favor of what the prosecution argued.
And I'll just go through some of these facts, right? Because, I just think it's important that you guys understand how they're not going to win this. So Allen never said he wore a blue Carhartt. He said he was wearing the same jacket. He was wearing a Carhartt jacket, right? They argue over whether it was blue or tan. That's the kind of thing they're arguing over. Was it a blue Carhartt jacket or was it a tan Carhartt jacket? Because that could make a big difference. That is not the kind of fact that's going to rise to overturning this conviction.
Especially when you have Richard Allen saying that he wore a Carhartt jacket and they found a Carhartt jacket in his closet, and you have on video what appears to be a Carhartt jacket, and then multiple witnesses who also saw a man wearing a Carhartt jacket.
Oh, but they include in here that he bought his blue Carhartt jacket a couple years before 2022. And this is like, kids, if you want to be appellate lawyers and you want to win, you can't do this kind of stuff, okay? It is so easy to attack this stuff. What is that based on? That's based on Richard Allen's wife saying that she thought they bought it a couple years before 2022. That is not proof that he did not own that blue Carhartt jacket in 2017. And it certainly is not proof that there was a lie in the affidavit about him owning a blue Carhartt jacket. And that kind of stuff is just... it's such a loser, and it's a glaring, just blinking red flag. And it's so easy to attack that if you're the state. They're really hammering these things. They're repeating them over and over again. And it's going to be so easy for the state to say, well, okay, this isn't accurate. Here's the transcript where Richard Allen says X. They're relying on this. That's unreliable. And the witness did say he was bloody. So that kind of stuff, it's just going to blow this out of the water. And this is their strongest argument. I don't know if we read all this case law or not, because I was reading the thing. But I do want to point this out, because this is from an Indiana case, because I think this is important. Once again, just so you understand how difficult this hill is to climb, because I want you, when you're listening to people talk about this, to have a real understanding of what's going on here. So this is quotes from the Indiana cases about this. To determine whether a police officer's affidavit sets forth probable cause to issue a search warrant, the issuing magistrate must simply make a practical, common sense decision whether, given all circumstances set forth in the affidavit, there is a fair probability that contraband or evidence of a crime will be found in a particular place. That's the issuing magistrate judge, right? So very low bar to even get to probable cause. Even if you were to knock out some of these statements, which remember, that's all you get to do. If you prove that he lied about it being a blue one, it was tan. Okay, fine. We'll kick that statement out and leave muddy and bloody. But then it's even worse.
It's even worse, right? That again, that's the magistrate judge who's issuing it. The reviewing court, remember, has so much deference to the court issuing the actual warrant. So the reviewing court isn't held to that low of a standard. They're not actually making a probable cause determination. Rather, this is from Indiana case law, quoted, the reviewing court's duty is to determine whether the issuing magistrate had a substantial basis for concluding that probable cause existed. If we do blockchain, this is chains away. We're moving further away from the causation here. They don't have to determine whether there actually was. They just have to see if that magistrate had a substantial basis to conclude that there was probable cause. So it doesn't even matter if there's not probable cause. If that magistrate had substantial basis, we're good. That's what the reviewing court, the appellate court standard is.
The thumb on the scale in the Franks motion is just so... Because remember, this was an exception the Supreme Court made for extraordinary circumstances, not for, the police are incompetent, not for your typical true crime case. Incompetent, bumbling police, got tunnel vision, didn't know what they were doing, misremembered, thought that she said it was the blue jacket, but she really said it was a tan jacket. It's not for that. It's for like the stuff that went on in Baltimore, where they planted the evidence and then had an affidavit saying they found cocaine on the guy when in fact they planted it on him. That's what a Franks hearing is really about. And as the court went on to say, in determining whether an affidavit provided probable cause for the issuance of a search warrant, doubtful cases are to be resolved in favor of upholding the warrant. So the just level that this is stacked against Allen, it's massive. It's a huge hill to climb. And frankly, it would be a huge hill to climb if his attorneys had done a really good job in the underlying court, establishing a record, really hammering home on things, setting all this up. And frankly, they didn't do that because they were so focused on Odinism that the record they're relying on is incredibly weak. And I think it's one of the reasons you see the appellate attorneys, who they're fine. I mean, this is a competent piece of writing, which is more than I can say for a lot of the motions by Richard Allen's defense. But that's why they're having to reach and sort of make some of these absurd statements, because they don't have a whole lot to stand on. They just, even though this is supposedly their strongest argument, it's the first argument, it's really not.
I don't know if we said the incredibly obvious, but the reason we're going through the Indiana standards for the reviewing court is because all of these arguments you've heard before, they're based on the record that was kind of poorly developed at the district court anyway. We said this before of the defense. And despite what you read in this, not even despite, read it with your own eyes. I mean, it's not very difficult to see. There's an incredibly low chance that this appeal will get granted and the conviction will get thrown out. But look, almost every conviction is appealed. You have the right to be convicted. That's one of the things that you get to do. By the way, if there's an acquittal, the prosecution doesn't get to appeal. But if there's a conviction, the defendant gets to appeal. And one of the reasons you go to trial is to preserve your right to appeal. Because when you enter a plea deal, almost 100% of the time, you are, actually, I've never seen a situation where you do not waive your right to an appeal. So this is one of the rights that you maintain. And so it's not uncommon. In fact, it's incredibly common to see an appeal after a conviction. And when you have a weak case, like Richard Allen does, this is the type of brief you see. So this is a commonplace brief. We see it all the time. He has a right to file it. He's doing the best that he can with the facts that he has, which are not very good for him. And the law is not on his side. And the outcome of this, I don't even have to read the state's response to let you know, is that it will very likely just get denied across the board.
We really could just end there, I mean, frankly, because Alice, I mean, it's so true. Like,
I just wanted to say the obvious.
Every case is appealed. If there's a trial, I mean, like I said, it is an outlier of outliers if it's not, because that's one of the reasons you go to trial. Usually if you plead guilty, you waive your right to appeal, especially in a case where you get 2 life sentences and you're going to die in prison. You're going to appeal, right? That's going to happen.
Like, why not?
Yeah, why not? Of the many briefs you might see in a case, this is an incredibly weak brief, and we're going to keep going through it. But, you know, I had recently a case with 2 guys who murdered someone. It was a murder for hire situation. And they actually had some of the dude did it defense, and that was their argument. And it was wasn't that strong, but it was a stronger one than this, right? And litigated that case, and they lost. But, you know, you see a brief like that, and you're like, well, this is a little different, right? It doesn't come up that often. You know, this could be interesting. We had a oral argument on it. Like, you never know. But typically, a brief like this, I mean, this is not an extraordinary brief. It's not a situation where, like, man, they got an issue right there. That is a really interesting one. Now, we're going to get to the second one, which I think is a little bit more interesting just because it's kind of weird what all went down. But another thing you need to think about is how you win. How do you win this, right? So if you're Richard Allen, you kind of have to win across the board. You got to win the Franks hearing and the Franks motion to exclude the gun evidence, which puts your bullet at the scene, right? The evidence, I mean, honestly, that's all it excludes. I mean, that would be it. You'd still have all these witnesses putting someone who looks just like Richard Allen there, and him putting himself there at exactly the time of the crime. But you got to win that. Then, the second issue is about the confessions. Because remember, he made 60-something statements which are incriminating. So issue number 2, they have to try and challenge these statements. Now, you might wonder, why is this not issue number one? Well, I think one reason is Richard Allen's defense attorneys did a really poor job building the record, because what they needed to do, they needed to challenge every single statement that Richard Allen made. They needed to say why every single statement was involuntary and why it needed to be thrown out. And the brief could have gone through that in a very sort of methodical way about every statement. They didn't do that, and so the brief doesn't do it either. Instead, the brief kind of reads like some of the YouTubers on this, because it starts off, the trial court erred, this is issue 2, by admitting statements Allen made while gravely disabled during his unprecedented pretrial solitary confinement, which it wasn't, in a maximum security prison. And then, once again, kids out there who want to be appellate attorneys, if you write a brief and immediately after your heading you have a quote from Nelson Mandela, you're going to lose. Okay? Like, it's like saying this is just like the Nazis, right? Like, if you're making that argument, you have already lost. Like, you are telegraphing to me, okay, so you don't actually have a real argument based in law, so you're going purely sort of grandiose emotion. And that's what we have here. Immediately we have a Nelson Mandela,
a block
South
quote.
Africa.
A block quote at that.
A block quote about solitary confinement.
Because that's how long it is. You have to block quote if it's over 50. That's like the blue book rule of citations. If it's over 50 words, you have to block quote it. So the fact that it's block quoted means it's over 50 words, which is a very long quote.
I mean, it is hard.
It's so
to
grandiose.
imagine.
It's dramatic. It's for maybe a closing argument, except this was not part of the trial whatsoever. We've already talked about is why he was in solitary confinement, why he was in maximum security prison. He was accused of murdering 2 young girls and obstructing justice and lying about it for many years. And then he was in solitary for his own.
And it wasn't even in solitary.
It wasn't solitary. Yeah, he was protected. Honestly, he was protected in prison. I'm not even sure we should have allowed him to be protected, because you know why he had to be protected? Because the other prisoners, who were also in there for really serious violent crimes, hated his guts because of the heinous crimes that he was convicted of.
And by the way, this is how the oral argument would go if it happens. And this is, the oral argument will be, so your client, like Nelson Mandela, was in solitary confinement? Well, wasn't he in solitary confinement for his own protection? Oh, so you don't think he would have been a target if he'd have been in general population? Oh, you think it would have been fine if the state had just put him in with a bunch of other people who wanted to kill him? And you include in your brief, by the way, where people who were in that prison and in the jail were threatening him. How does that help your argument? Because that's the thing.
By the way, just really quick, I know we've made this point before. Flip it around. If he were in Gen Pop and he were shivved in the shower, which he would have 1000% been because of all of these threats that he was facing that is included in this brief,
and then
they would have brought a civil rights action against the state for not protecting him when they should have known, because there were all these well-known threats against his life, and they didn't take actions to protect him because he was in their custody. Just by the way.
I got to point this out. I pointed this out in the last time I talked about it, but it's so egregious. And once again, such an obvious weakness to this, because, okay, let's talk about the law for a second. So this is a confession case. If confessions are not the result of custodial interrogation, they are presumptively admissible, right? Your words are admissible against you. So unless it's one of those, you have the right to remain silent situations where, the police are questioning you under hot lights and you ask for your attorney and they say, no attorney for you. And in fact, I'm going to shoot you if you don't tell me the truth, right? I mean, like, that's typically where they try and throw confessions out. And once again, they're trying to throw them out. So just think about West Memphis 3. Like in West Memphis 3, they weren't trying to throw those confessions out. They were just trying to introduce evidence to weaken them, to say like, hey, you shouldn't take these as seriously. They're trying to throw these out, which is a much higher bar. They have to prove they're involuntary. Well, so they have this huge hurdle because it's just him talking. These are not interrogations. These are not he's sitting in a room with cops. These are things he told other inmates, things he told his psychiatrist, things he wrote to the warden, et cetera, et cetera. So what they do is they try and rely on some of these cases, rare cases, that say the conditions of confinement can overcome your ability to not falsely confess, and therefore these aren't really voluntary and they need to be suppressed. The problem is And you might think, okay, that seems like a necessary path, and that's important. The problem is the case law is against them even here. So the way they present it is going to be used as a hammer against them. And I have to cite this one case for you guys because I think this is so emblematic of what they did. It's called United States versus Karaki. I don't know if that's how you pronounce it, because as you're going to see, it is a name from someone in a foreign country. It's a District of D.C. case because, once again, they can't really cite to Indiana cases because this is such a rare and difficult argument to make. And here's the quote they use. Months spent in solitary confinement, which, once again, he was not in solitary confinement. He had an iPad and contact with the outside world, and he got to meet with his counselor, but that's not the point. Deprived of light. Is there any indication he was deprived of light? I'm not sure. Adequate food. I mean, I don't think that's right. In fact, he was eating his own poo, so he had plenty to eat. And contact with the outside world, which, once again, he had his iPad until he broke it, is by itself sufficient to sustain a finding of voluntariness. So even the quote itself is weak, but let me give you the background, because if you read the facts section of this case, what you will learn is this case is from Rwanda, because this is a case from a Rwandan prison camp where someone who was accused of being involved in the genocide was taken into custody by Rwandan officials, basically tortured until he was ready to confess. Then the Americans show up and they're like, here you go. He's ready to confess. And of course he confesses. That is what this case is about. Not in any way analogous to the situation that Richard Allen found himself in.
I got nothing to add to that. This is why you read cases, by the way.
This is why you read cases.
So
exactly.
Just so you know, if you are not reading this brief yourself, you should. This is on page 72. They cite Karaki with just the quote that Brett stated, the month spent in solitary confinement, deprived of light, etc. And that's it. They don't give any background, which is fine. You don't typically give an entire case background. But that is why when you're the judge reading the brief or you're the state responding, you read all the cases and you see if the case actually stands for what they say it does. And the facts matter because we said that this is in the common law system. The facts matter for each case because it's not a math problem. We don't now say every situation where there's no light, no adequate food, and no contact with the outside world equals involuntary confinement. That's not how it works, right? The facts matter here. The facts here do not support what Richard Allen is trying to argue.
And I think this is one place where the appellate attorneys got sucked into some of the online commentary because the whole he's a prisoner of war. John McCain, who they actually mentioned John McCain in here, was treated better in the Hanoi Hilton. I mean, it's just it's insulting. It is insulting to
actual prisoners
the intelligence. Of war. Yeah, and actual prisoners of war. And the thing is, once again, appellate briefs, and I see this all the time, frankly, with trial attorneys. Trial attorneys often, because this is what you kind of want to do, in front of a jury. I mean, think about Alan Jackson or Johnny Cochran, right? I mean, you're bombastic and you're verbose and you're over the top. And that works with juries, but it does not work with appellate judges. That brings us to section 3. This is the last section. So basically they make 3 overarching arguments. And
we're really jumping a lot of these though. This is just really, we shouldn't go through all of them, but guys, there's 6 subsections about his solitary confinement. And we've already talked about the solitary confinement, how it wasn't solitary confinement, but that's what they're doing. They're just dragging out. You want to talk about if attorneys are paid per word? They really earned their words here because they make the same argument in 6 different ways about his psychosis from no one ever said that being in prison was fun. So I just want to make a note that they really go into all of it. And they go into all of it, I think, more for the sensationalism of trying to paint the picture that the defense counsel were at the trial level of showing him in his dirty clothes, saying he ate his own feces, and eating paper, eating his evidence, things like that, to basically draw out sympathy, I think is what they're trying to do. I'm not even exactly sure, but their argument falls flat here.
So, and just to give you some examples, right? I don't want to spend all day on this, but why are they quoting Nelson Mandela? Why are they quoting John McCain? Why are they doing it this way? Well, because what should have happened, if you're a good defense attorney for someone, is you should have gotten an expert, someone who examined Richard Allen, who said he was willing to say that his will was overborne, he was broken by this. You know, this person testifies at an evidentiary hearing where you've laid out all the different statements he made, 1 through 67, and how all of them are the result of his confinement. And, you know, and then in your appeal, you're citing that person. You're not citing Nelson Mandela for the sort of general idea that solitary confinement is bad for you. You're citing an actual expert in this case, explaining how these circumstances are exactly the kind of circumstances that would break someone's will. But they can't do that.
Because they don't have it.
Because they don't
have an expert. And I'm sorry, I forgot that they even quoted Dostoevsky. I forgot they even quoted him in saying the degree of civilization in a society can be judged by entering its prisons. Yes, but this prison and his conditions, not at issue here because they don't have the experts and they don't have the facts in the record to prove that. So this is more like of an overarching, like, metaphysical question of what is imprisonment, which is also what they did at the defense level and all the appellate attorneys really can do because they have nothing to point to.
Like, they try and argue that the state court should have let in some settlement decree in a lawsuit about Indiana solitary confinement, which isn't specific to him, doesn't involve him. It's just the utter incompetence of the trial attorneys, which we're going to talk about in a second. It's just its own display. It really is. And I have to say, the thing that happens after this will be the ineffective assistance of counsel claim. That will happen after this. And I would urge the state and urge the people responding to this, don't go too hard on the defense attorneys, because you could just like crush them, right? You could just talk about how basically all of these fail because of the immense failures of Richard Allen's defense attorneys. You could do that. But that would be a mistake because then,
they are going to the IAC, right?
When it's ineffective,
focus on the facts because the facts are really bad already. You don't have to go all the way to the IAC. Don't give them that bone.
Okay, so getting through this ridiculously, and look, I
have to keep scrolling because it's so lengthy.
This is also very clearly written in part for the public,
defendant too.
Yeah, and for the defendant. Yeah, I mean that's okay. So issue 3. Is the court denied Allen his right to present a complete defense, to explain the scene, and impeach the investigation. So you have a constitutional right to present a complete defense. This is ordinarily a very weak argument because trials for both the prosecution and the defense are governed by the rules of evidence, and the rules of evidence determine what comes in and what doesn't come in, and it's within the judge's discretion to decide that.
Incredibly broad discretion. They even say it in their own standard. They're like, although the trial courts have broad discretion in conducting trials, like they even recognize it because they have to because of that incredibly broad discretion.
Right. The discretion has constitutional limits. Of course it does. Right. But so that's where they're set. Right. They're having to deal with this, and basically they want to make this into a constitutional issue because then you get de novo review. And that is important because there's less discretion.
And they're not bound by the record, which is what they have here.
So just to tell you how incredibly weak Odinism is. They don't start with Odinism. They start with a really dumb argument that the court committed reversible error by excluding the first sketch of Bridge Guy. So the sketch of Bridge Guy is number 1, hearsay, number 2, irrelevant, and number 3, not an issue because guess what? The person who provided the information for the sketch testified. So anything you can get from the sketch, you can get from her because she can say, that's not the guy I saw. That dude sitting at the table doesn't look anything like him. You know, I described him as being young with curly hair, right? Like that's how evidence comes in the real world. And once again, the fact that this is their first argument in the incomplete defense, this is an eye roller, right? You're just going to roll your eyes at this argument if you're an appellate court judge. And why are you making it, frankly?
And it goes on for like 5 pages of why it's so bad that this sketch wasn't. All you have to know is that the person testified. They were cross-examined, and they can say what they are. They didn't draw this picture. We all know that. If I had to draw a picture of Brett right now, it would look nothing like him. It probably look like Elf on the Shelf. But I could get on the stand and describe to you what I saw and then point to him and say what I actually saw. That's why all of the 5 pages of argumentation here is really just, it goes straight in the trash.
And so the next argument also is going to go straight in the trash, but they're going to tell you why, which is always helpful. So the court committed reversible error in excluding Tobin's testimony. Tobin, you may recall, was the expert they wanted to testify about the bullet, right? So judges have extraordinary discretion when considering experts and which expert evidence to let in. Here's how they describe the issue. The judge excluded him because he was not a firearms expert. He was untrained in firearms identification. He did not examine the evidence in this case, and he did not conduct a firearms examination. If I'm the state, I copy and paste that into my argument and then say, we have nothing else to add. Because that's exactly why she excluded him.
This is the discretion of the court, and the court had substantial basis on which to rely on that. I would just say, see page 92 of brief.
And once again, why didn't the attorneys try and get an actual expert? There are former ATF agents who testify for defense attorneys who would have been experts in this. Now, the charitable reason is because if they had have, they'd have said, sorry, seems like it matches to me, right? So instead they get somebody who doesn't really know what he's talking about, who's willing to say, well, in my experience, this is like junk science or whatever. So that's out. The court committed reversible error in admitting hearsay to rehabilitate the timeline upon which the state built its entire case. So this is silly. So this is basically, remember the stupid argument the defense made where it was like, someone plugged in headphones into Libby's phone at this time, and so therefore that means that her phone was being used right when they think she was being killed, which is just a dumb argument. And I don't even know, you don't even really have to refute that, but they did. So they recalled their expert, and he basically said, look, you know, I've looked into this, and there's a couple things that could cause that. There could be water in the phone, there could be dirt in the phone, all that sort of stuff.
Both of which was found around the phone.
Exactly. And, you know, evidence, maybe not 101, but we'll say 102, is that experts in issuing an opinion can rely on hearsay. It's one of the foundational principles of the 700 series, is that they can rely on hearsay. Because obviously they can rely on hearsay because they weren't there. They're not fact witnesses.
They're looking at the facts to tell you in their expert opinion what's happening. That's the whole basis of what they're doing.
That's the whole basis. So making a hearsay objection to an expert's testimony is just like,
the whole basis of an expert is to listen to hearsay or to examine hearsay.
So then they argue, these are just, I don't know why I'm going through these, that they showed the video.
You're giving it way more credence than like even the attorneys do, to be honest.
They showed the video of Alan's confessions, but they didn't show the audio, which is so firmly in the discretion of the judge, because there were obvious reasons that the defense wouldn't want to include the audio, because he's saying all sorts of crazy stuff. So they got in him acting crazy without hearing the crazy stuff he's saying, which obviously the jury would have been prejudiced by. So that's like silliness. Committed reversible error in prohibiting the jury from hearing 2 phone calls Alan made. Here's the thing about hearsay. You don't get to admit your own statements in an effort to make yourself look better. That's not how it works.
You know why? Because you get to take the stand if that's what you want to do. So, and the reason that the prosecution can admit your statements of the party opponent is because they can't force you, because of the Fifth Amendment, to testify. But you yourself don't get to rely on that, because your response to that is to take the stand in your own defense, which you also have the constitutional right not to do. But if you do this, then you have your cake and eat it too. So you have to take the stand if you want to refute it. You don't get to just use other things, because guess what we'd all do? Make phone recordings ahead of time that make us look good.
They then, same thing, they have an expert who said he's psychotic, but they wouldn't let the expert enter Richard Allen's statements about him being psychotic. Hearsay. I didn't know why we're dealing with this. Oh, and then finally, here we are 50 minutes in, we get to our ritual killing, that this was really Odinism all along. And the thing is, what's funny, you read people online, and they really think, oh, they saved the best for last. You know, it's like a novel. We got through all that other stuff, and we end with a bang. We ended with the Odinism. No, that's not it. That's not it at all. Don Perlmutter, the worst expert ever, They talk about how she should have been able to testify, even though she's woefully unqualified. I mean, basically, they think their Odinism expert should have been able to testify. But as we said, judges have so much discretion on expert testimony. And the huge problem, and the thing about some other dude did it defense, you have to connect you're some other dude to the case, and you have to put forward some evidence that they could have been involved. And the problem they have is all their people have alibis. Like their main guy, the guy they've slandered for the last year and a half, who's an Odinist, was at work. We know he was at work. And after he was at work, he went to the gym. So he could not have done this, which then you have to get into all the crazy conspiracy theories about how, like, oh, well, maybe the girls were killed somewhere else, and then their bodies were taken back to the place they were kidnapped while people were looking for them, and then they did their Odinist ritual. And even in their fact section, they acknowledge how much blood was at the scene, which, by the way, wouldn't be there if they were killed somewhere else. So, it's a filing, it's an appeal, it's more competent than what we saw with the trial team, frankly, just because Odinism comes last. That they're more competent. They were smart enough not to include it. They had to include it at some point because there would have been uproar if they hadn't talked about Odinism. But they put it as far to the back as they could possibly do because they know it's a waste of an argument. So look, they're going to lose this. They'll probably give a moral argument just because it's a double murder. I mean,
jeez. What a waste of time. They've already taken up so much time at the appellate courts. If I were them, because of what they did at the Supreme Court, I would not have oral argument. But you're right. When you have a 100-plus page brief and it was a lengthy trial and a double homicide, I'd probably have argument too.
And I'll say this. The worst thing that could happen to Richard Allen was he won the Supreme Court.
Yep.
Mandamus.
Absolutely.
Because they gave him one. They're done. They're not gonna rule in his favor again. They're just not going to. I know the court I practice in, typically, if it's life without parole or death penalty, it basically automatically gets oral argument. So I could see that happening here. The real interesting thing. So just to give you a timeline, this was filed mid-December. You have 30 days to respond. Obviously, the state will ask for an additional 90 days or so. They'll probably ask for a second extension, just like they did. I mean, remember, he was convicted, October 2024? And we got his brief a year and 2 months later.
After they filed so many extensions. Do you remember that?
Oh, yeah.
Extension
and if
after
I'm
extension.
the state, I file extension for extension. Every extension they filed for, I ask for one. I'm asking for...
Oh, absolutely.
A lot of times, the state doesn't get as many. But best case, I think absolute best case, we get the response from the state in April, May. Best case. Mm-hmm. So then... they get to file a reply brief, which they will delay.
They will ask for extension upon extension.
They will. They will then file that. We'll be generous once again and say they file their reply in August. The opinion probably comes out. Say there's not oral argument. Even without oral argument, I don't think we get... Look, I've never practiced in Indiana. Maybe it's a much faster process than it is in the places I have practiced. But I'm thinking if briefing is complete in August, summer of 2027 for an opinion, and that's with no
delays,
argument,
right? That's right.
Delays. And then after that, they'll file a petition for review at the Indiana Supreme Court, which I think is in Indiana is discretionary. Could be wrong about that. Didn't really look into it.
Usually they are, but...
I could ask ChatGPT real quick if you really want to know. So then you have to go straight to the United States Supreme Court. So once the Indiana Supreme Court denies, you have to seek cert with the United States Supreme Court, which will be denied so fast, it won't even be funny. They'll deny that. So then you're done with your direct appeal. Direct appeal is over. So now we get into collateral attacks. So you may have noticed there is no ineffective assistance of counsel claim in this brief. The reason for that is that although you can bring it on direct appeal, almost no one does. And the courts will generally deny it with leave to refile on the basis that you didn't create enough of a record. Because typically, remember, you're attacking the trial team. So a lot of times you want to get affidavits, you want to come up with things that they should have argued, you want to have a hearing where you put them on the stand and ask them why they're such idiots. If you think Richard Allen is guilty and you hate his defense team, the ineffective assistance of counsel brief is going to be glorious. It is going to be so amazing because it's going to be 300 pages of these two are the dumbest, most incompetent trial counsel in the history of the law. And it's just going to be...
I wonder if the prosecution will be like, whoa, can we write that one?
Yeah, I mean, it's just going to... They are going to hammer them. And if they don't, they're incompetent. I mean, it's going to be a massacre. The only bad thing about it is usually those fail, but in this case, who knows? They may actually have a good argument. I'll be interested. I'm more concerned about that than I am about this.
Yeah,
I'll say that.
I agree because they clearly are ineffective, but they also got everything they asked for. So did it make an outcome difference? No.
And I want to say this. People often say, well, how can they argue for ineffective assistance of counsel when he fought so hard to keep them? Okay, so that thing, I think he's waived. So he can't say, for instance, you leaked a bunch of photographs. That really hurt my case. You're ineffective for that. That is waived, right? But that doesn't mean he waives everything else. That doesn't mean that his attorneys could just have gone on like a cocaine bender in Mexico during the trial and he couldn't claim ineffective assistance of counsel. He still can and he will. And we'll just have to see exactly how it goes. But that one, I mean, coming to you in 2028, ineffective assistance of counsel claim by Richard Allen is going to be something else to read. If you're elderly and you're trying to hang on until 2028 just to read that. I mean, it's going to be something.
It's going to be a banger.
It's going to be a banger. Yeah, it's going to be amazing. All right, Alice, do you have anything else on the...
No, what a way to start off the year, though. Maybe we should answer some questions.
Sure, why not?
Waited so long.
So as most of you are well aware, I think, if you leave a 5-star review, you can leave a question and we will answer it. And this one, I thought this one was funny because it's like, it just got more sort of frantic as it goes. So here's what they say.
The question got more frantic?
Yes.
Oh my.
Here's my question. Do you take the polygraph or not? Do you lawyer up or not? What's an honest citizen who stumbles upon a body to do? What would Brett and Alice do? You're walking down the street and encounter an abandoned murder victim. You call 911. You guys always say the person who finds the body is an immediate suspect. So knowing this, do you speak to the police without a lawyer or not? Do you take a polygraph or not? If you don't take it, you're uncooperative and raise suspicions. If you do take it and it's inconclusive or you fail, you're suspicious. Or you could even pass and they could lie to you and say you didn't. So that's the question.
Oh my goodness. Okay, whoever asked that, take a deep breath.
Take a deep breath.
Whew. Okay, let me just say something to you.
It's kind of like quicksand. You probably don't have to worry about it.
I was going to say, for the person who asked that question, let me say, number one, if you did it, you should just turn yourself in because I think the guilt will eat you alive.
Yeah, you're not going to.
Number one. Number two, the question sounds like you didn't do it and that you are not in a situation where any of this has happened and you're in a downward spiral of fear. So let's start from the beginning.
And look, I mean...
We may have different advice, too. I don't know.
Well, like everything else, it's a situational thing, right? I mean...
If I were hiking with a group and I'm hiking out in the trails and I stumble upon a dead body, run to the cops. Oh my gosh, yes. If I am in my backyard for some reason digging a grave and I uncover a plastic body that's on my property and I was digging in that place and was like trying to do a 6-foot hole to bury something else, maybe my dog, and I hit a body, maybe, you look pretty guilty.
Yes.
That's where the situational thing comes in.
Then you just put your body on top of
on top body. And you covered it up.
Because apparently whoever did that got away with it. Yeah, I mean, it's kind of like there's that meme that goes around. And it's like my daughter wants to donate her hair to Locks for Love, but she's afraid that someone will commit a crime and they'll leave a hair and she'll be implicated. Okay, so let's say you donated your hair and you live in Alabama and somebody in Seattle robs a bank and they leave the hair and the police find it. Well, guess what's not going to happen? They're not going to arrest you and charge you with a crime because they're going to say there must be some other explanation for this. You were obviously in Alabama when the robbery happened in Seattle. Oh, you donated to Locks for Love? Well, that's it.
And they have a record of it too, right?
Exactly. So, like in this case, I think what you often see with people who are innocent but end up being convicted is they're already bad people, right? So like you're robbing a house and you break into the house and somebody has been murdered there. And you're like, oh, wow, this is bad. And then you leave, you run, right? And then the police come along and they find the house broken into and they find a body. What are they going to think? Somebody broke into the house and they killed this person. And then they find evidence on the broken door, your fingerprint on the broken door. And they come get you and they're like, were you in this area? And you lie and you say, no, and I wasn't around there. And they can prove it, right? Then you've basically walked yourself into a situation where you're liable to be falsely convicted of a crime, right? That kind of situation. If you're that person, you got to make your decisions. Like, if my kid was in danger or kidnapped or something, like, I'm basically going to tell the police anything they want to hear up until the point where I think they're starting to think I'm guilty. And then I'm going to lawyer up because I'm like, you guys have screwed this up because you're looking at me and I didn't do it. And so now I'm going to fight you. So I will work with you as long as we are working towards the goal. The moment I think we're not working towards the goal, that's when I'm starting to fight you. That's sort of how I would approach it. But I'll just say this. If you're just a normal person and you come across a body and you like run away and don't report it, that's super, super suspicious.
Mm-hmm. And
So-
may potentially, depending on what you do, qualify you for like obstruction of justice at some point. So like if you happen upon a body and you didn't do it, report it and talk to the cops and tell them how you found it.
Now, I would be very skeptical about taking a polygraph just because I
would
don't
basically
think I
never
can
take a
pass one.
polygraph in general. I don't think they're admissible. They can be used as tools to interrogate you. And you kind of don't win taking a polygraph test no matter what. It's not going to prove your innocence because it's just a biometric test and it's not admissible. So it's not for court anyway. And I could be like, look, I'm not going to take a polygraph test because I'm a lawyer. I know that they're not, or I listen to Alice and Brett. I know they're not admissible. I know that you don't have to tell me the results of it. It's an interrogation tool, but I'm willing to talk to you because I want to help you figure out what's going on. So just talk to me and you can use your own eyes and assess my biometrics and decide if I'm lying or not because I'm not lying.
Yeah, and I think the other one you mentioned, you talk about you're walking down the street and you encounter someone, you always say the person who finds the body is an immediate suspect. Yeah, for like 5 seconds.
It just means they have to be cleared.
Yeah, they
Just
have
like
to
the
clear
boyfriend
you.
has to be cleared. It doesn't mean don't date anybody because the person you are dating might get murdered. No, that's not how you live your life. It just means you are cleared.
Right. They will have to go through that step of clearing you because
Which could be as simple as calling your work and saying, did they show up to work at this time? Okay, they're cleared.
yeah. Now maybe Richard Allen will still try and accuse you of being involved in a ritualistic murder, and there will be idiots online who believe that, but the police are not going to, so you're going to be fine. All right. Do you want to answer another one, or is
Yeah,
that
that was fun.
Are you satisfied? Oh, these
That was great. That was
fun.
great. I felt the anxiety and I wanted to talk him down from it. Like, you're okay, man. But if you did it, you should really turn yourself in because I don't think you can handle the guilt.
Yeah, you will not be able to get past it. Okay, so this is similar. This is Be More Mal. I guess I should tell you who said that in a second. So Be More Mal wants to know, what are your thoughts on allowing the police to lie to suspects / interviewees? I don't have any problem with it at all.
Me neither. It's an interrogation tool. It's like the polygraph. There are obviously ways that are frowned upon, I guess. But think about the way that you are trying to extract information from anyone in your life, whether it's your kids, the waiter, the delivery people, someone who works for you. You can indicate that you know more than you actually know. Say you have an employee who has been stealing from the cash register and you strongly suspect it, and you may even have some footage, but like the footage is not really clear because they're obscuring the cash register, but you see them like opening the cash register. Is it okay? Is it ethical for you to say, hey, Billy, I know you're stealing from the cash register. I know you're doing it every single day. So why don't you fess up right now? If you leave the money on the table, all of it. I know every cent you've taken. Leave it all on the table. I'm not going to call the cops. Do you actually know every cent? Do you actually know for sure that they do it? No. Is that unethical for you to confront them when you have like reasonable belief that that may lead you to their confession and then maybe to avoid like a bigger situation? I think that's fine.
And also, I think this is one of those situations where we need to be adults here and make an actual calculus about what this means, because so often we approach these issues with these black or white approaches where it's like, oh, it's either fully just or fully unjust, and we can't do the unjust thing, so therefore we can't do it. Here in the real world, we have to make cost benefit analysis, right? So usually the argument for why you can't do this is like, well, someone like Jesse Misskelley, if you lie to him, he may end up confessing falsely, and then you have the West Memphis 3. Okay, fine. Yes, that is a danger that happens on occasion. Pretty rare, but it does happen. For the 99% of the cases, the thousands of cases that go through police departments every day, it's a valuable tool used against ordinary people of common intelligence or whatever. Okay. So to prevent the Jesse Misskelley circumstance, how many technicalities are you willing to give defense attorneys? Like, how many opportunities do you want to have to throw out confessions, valid confessions that are supported by evidence? How are you going to draw this line? What is a lie? Is it saying, we know you did it? Is that a lie? Or is it, as Alice said, acting like you know more than you do? We have surveillance footage when you don't. I mean, that's a lie, right? But it's not telling the person, like, that's the kind of lie, we have surveillance footage, that would make someone who's guilty say, oh, okay, you got me. Yeah, I did it, right? But someone who's innocent, you would not think that would overbear them to the point where they're like, oh, you have surveillance footage? Well, I must be on it, even though I'm innocent, right? It's just like, so how do you draw that line? And how are you going to draw that line in a way that's administrable, that's easily applied to the numerous situations we see every day in police departments? Like, this is not as easy as just saying cops can't lie to suspects anymore. It's something that would be much more difficult to draw. And frankly, I think the cost to society of having that rule would be much greater than whatever benefit you get from the occasional person who was convinced to falsely confess because the police lied to them, which I just don't think happens that often.
Yeah, that cost benefit is one that I'm willing to make in order to be able to solve cases, basically.
And I just think you got to do it all the time. I mean, whenever you talk about these, always do the cost benefit analysis. You have to think that way because life's not perfect, right? We don't live in a perfect world where we can just do the right thing. So we're never going to tell a lie because lying is wrong. So we're not going to do that. Like, no, you cannot function in society like that.
And by the way, that's because we're working with people who are not playing by the rules. And so you hamper investigative tools when you don't give them any tools in the toolbox. And we're not talking about torture. We're not talking about waterboarding. We're not talking about all of these things that are alleged in Richard Allen's appellate motion here. We're talking about using your words to indicate that basically more than you actually do. And at the end of the day, if you don't have the facts, you can't use those lies as evidence. Those are just investigative tools to lead you hopefully closer to the truth. Because at the end of the day, if you don't have the facts, then you don't have a case.
And look, you can always present evidence to the jury that the person was lied to. I mean, you can absolutely do that. Oh, you confess. Well, you lied to him. You said you had this, didn't you? You said you had this. You lied to him the moment he walked in the door, right? I mean, those are all things juries can also consider and when they're weighing how much weight to give to these kind of confessions.
Wow. New year. We have this list of questions. You guys can add to it by leaving us a 5-star review. And look, it's a new year. Do another 5-star review. Leave us another question. We'll answer it. Guess what? We don't really count if you ask multiple questions. We just love you guys. Love these questions. And hope you learned something and enjoyed this episode. But also stay tuned because I think we're completely right. And we just told you what's going to happen in basically a year's time. And also for the next 2 years. I don't think there's going to be any surprises in this case. The conviction is going to stand. Richard Allen is exactly where he needs to be because he is a dangerous and conscienceless man, basically. Well, he might not be conscienceless because he did confess like 60 plus times. So maybe he does have some conscience, but it's been knocked out of him since he felt the conscience. So I do think he is where he belongs. And I think the appellate court will uphold the conviction handily. Is there anything else you want to add, Brett?
I mean, the only thing I'll say, if he's not where he's supposed to be, this ain't going to get him out of there.
That's a fair point.
So he's going to lose this appeal. And the great thing about this, people wanted to argue with me about this on X. I'm like, I'm not going to argue about this. Because guess what? In a year and a half, I'm going to be proven correct. And you won't apologize for all the stuff you said. So I might as well just sit back and watch it happen, which is what we can all do. But I would not lose sleep if you're someone who was glad that Richard Allen was convicted.
Fair enough. Well, guys, thought we'd come in hot for 2026. This was fun for me because I've missed talking to you, Brett. It's been like a whole week. We had Christmas, about to have New Year's when we're recording this. And I'm excited for this new year of podcasting with you.
Can't wait, Alice. Looking forward to it.
Indeed. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Look at that. Mm-hmm. Look at that. Okay.
Look at that.
Okay, we're gonna work on my
It's been so long.
It has been a long time.
An eternity.
I know. Merry Christmas. Did you have a good Christmas?
I did. Merry Christmas to you too.
Thank you.
Happy New Year.
And a Happy New Year.
Alice looks so young. You look so young, Alice.
Maybe because there's actually light in here.
Maybe.
As opposed to in the closet.
Yeah. How do you get that light up here?
Oh my goodness. Oh, you guys. It's been a week.
Pluto TV has thousands of free movies and TV shows.
What? This is the mindset. Free. This is the mantra.
Free.
This is the mindset.
With movies like Joe Dirt, Pixels, and 50 First Dates. This is awesome. And TV shows like Survivor, SpongeBob SquarePants, The Fairly Odd Parents, and Ghosts. Pluto TV is always free.
Huzzah!
Pluto TV. Stream now, pay never.
You're welcome.